George Tanios is a January 6th defendant that we've talked about a lot here on the channel. You may remember that a few months ago, 3 months ago, we talked about it. These were the Capitol Hill cases. We have George Tanios and Julian Khater. These are also Capitol Hill cases. And if you remember, these were two gentlemen who were there at the event, and there was allegations that they were involved with bear spray, right? We're going to get into this, what happened, but they brought bear spray over to the scene at the Capitol. This is sort of what it looked like on the outside of the building. This is a clip from the original complaint, and you can see here it says the tipsters that turned these two gentlemen in was from a Facebook page that belonged to an individual named George Pierre Tanios. They confirmed that he was wearing this clothing, blah, blah, blah. So we see him in this surveillance footage here, figure 7, and this is a scene from some video footage that was there as well. And we're not going to get into it, right? I can't really play any of that stuff here on YouTube because they don't like it, they 18 plus your channel, and then you got to delete the video, so it's a problem. So we're just gonna sort of go through the court documents, and I want to show you with a little bit of background what's happening here. So this is a big deal. We've been talking about the January 6 protesters, Capitol Hill rioters, or the insurrectionists, whatever you want to call them, right? Defendants, people who are citizens of this country that deserve the presumption of innocence, that deserve appropriate release conditions and appropriate bonds being placed on them. That has not been happening for the last 8 months. And we learned yesterday when we were talking about a different case that the U.S. government is sort of dragging their feet on this. Apparently, they were working on a database that is going to be used to organize all of the thousands of hours of discovery, and they still don't have it ready for the defendants. They have not given it to them. Big problem. If you're a defendant, if you're somebody being charged with a crime, you kind of need to know what the evidence is against you so you can prepare your defense. Otherwise, you're flying blind. And so this becomes doubly problematic if at the same time that they're not giving you the evidence that you need to protect yourself, to do your defense, which is your constitutional right to have that provided to you. While they are doing that, they are delaying the cases, and they are holding all of this over your head, and they're not letting you out of custody while all that's happening. And they keep coming back to the court and saying, we need more time. We need a continuance. We need a continuance. Never mind your right to a speedy trial or any of your other due process rights. They have the obligation to provide the evidence. They're not doing it. And they're demanding more time in the interests of justice. And so I've been screaming on this channel for a long time about how offensive this is to justice in this country. And I don't care what the defendant is. I don't care if this was happening to any BLM protesters or Antifa protesters or Derek Chauvin. I don't care what it is. It's inappropriate for this to be happening and for the judges to be rubber stamping this. And in this case, George Pierre Tanios was arrested and held in custody and tried to get out multiple times. And a district court judge from the DC circuit came out and said many times, you're too dangerous. We cannot let you out on repeated occasions. So Tanios and his lawyer appealed this up to the U.S. Court of Appeals for the DC circuit, and the Court of Appeals came back and said, Tanios, you are right. They should have never kept you in custody for those reasons. It was clearly erroneous. It was problematic. And you are now going to be ordered to be out of custody. So it's a huge win, something that we have been saying here was the appropriate thing to do. And I'm very, very grateful that it happened. The question will be, will this domino into some of the other cases or catch fire? Or is this going to be reappealed to the entire panel there with the Court of Appeals? Because this was only a partial panel, and maybe they overturn this, right? Who knows where this goes? But for the time being, celebrate a victory. This is what justice looks like. Let's take a look at it. This is what the title of the complaint looks like, or of the order looks like. This is on appeal from the U.S. District Court for the District of Columbia, U.S. of America here versus George Pierre Tanios. You see the case. This was filed on August 9th. Already showed you, we did some heavy lifting on this a while ago. This was the image from the complaint, and this was count 1. And so you recall that 2 of these people were involved in this, and they were also alleged to have been involved in the death of Officer Sicknick. Remember, we spent a lot of time with him. This is why these 2 guys got so much attention, because allegedly the bear spray may have impacted Sicknick. Okay, so on January 6th, we know DC and elsewhere, they conspired, they agreed together to injure other U.S. Capitol police officers, particularly Sicknick. We've got Officer Edwards, Metro PD Chapman, and others, all engaged in the lawful discharge of their duties. Among the means by which they carried out these things, we have George Pierre Tanios armed themselves with a chemical spray and utilized the chemical spray against members of the U.S. Capitol Police and Metro PD assisting the U.S. Capitol Police. Okay, right? So it's the chemical spray. It's the bear spray. This was what we were seeing, right? And we went through this analysis in the prior videos. We were talking about this in depth, saying, hey, we went through and looked at all of the footage, right? There was clouds of smoke every which way. People were throwing stuff. There were water bottles in the air. There was all sorts of spray. So how does the government prove that any one of these two people was particularly, spraying that in one direction, and whether that hit Officer Sicknick? It turns out that was irrelevant. Officer Sicknick died of natural causes. They couldn't tie it back to these two guys, but they certainly tried. Now, if we sort of decompress all of that, right? A lot of mayhem there. They've got chemical spray. I want to go back to the date of the arrest, or nearby the arrest. Right after this happened, the judge did not let them out. Okay, so we're going to go back here to the Hill. You'll notice this date is from March 23rd of this year. West Virginia judge on Monday ordered a suspect in the chemical spraying of officers detained pending trial. Right, that was one of the early orders. This is George Pierre Tanios, was allegedly assaulted Officer Sicknick and two other agents with a chemical irritant. Seen on footage with Julian, Khater of Pennsylvania, working together according to the FBI. Neither of the men is charged with killing Sicknick, who died. During a hearing on Monday, prosecutors argued that Tanios, listen to this, this was back in March, okay, so we're talking about bear spray. This is interesting. During a hearing on Monday, back in March, prosecutors argued that Tanios purchased the bear and pepper sprays that he brought with him to D.C. Reuters reported. One of the sprays was allegedly used by Khater to spray the police. Right, so if you read that, it sounds like Tanios purchased it, Khater used it. So that alone was enough to be a part of this conspiracy and make him somebody that was so dangerous that the government couldn't let him out, right? He just bought the stuff. Somebody else used it. But he was there, and he was in the vicinity, and he just bought it, really. Somebody else used it, and then he got charged for it. Okay, so the judge takes all these factors into account. Oh my gosh, insurrection. This is the worst thing that's ever happened to America. The greatest assault on American democracy since, I don't know, the Civil War or whatever. They were saying everything basically. Greatest attack on America since, the Civil War. Everybody goes, did you forget about Pearl Harbor or 9/11 or any of those other, major attacks? Anyways, you get the point of it. Judge listens to the facts of the case and says, wow, my goodness, we can't let you out. This is just too dangerous. We saw this order here. This was filed actually in May. They tried multiple times. So you recall back in March, right, the judge did not let them out. Tried again in May. And the new order here from the judge says, well, the defendants here, they want to be released on bond pending trial. Okay, and we've seen many other people who've done much more heinous offenses, like Derek Chauvin, for example, who are out on bond, get released from custody. This guy, George Tanios, allegedly, according to The Hill, was purchasing bear spray that somebody gave to somebody. He gave to somebody else. Somebody may have used it somewhere on that particular day. Held in custody the entire time. Too dangerous. Government comes back out in May, can't do it. Government opposes both motions, this is the U.S. Attorney's Office. This is your government. This is Merrick Garland under Joe Biden. They're opposing the release on these things. They don't have to do that. That's a policy decision. Why are they doing that? Because these are political cases. Now we have, having considered, the judge says, all the materials submitted to the court, the evidence, the arguments by counsel, and the factors under U.S. Code, the court finds the defendants would pose a danger to the community if released. Court also finds that no condition, no combination of conditions of release would reasonably assure the safety of the community. For these reasons, this is now denied. The defendants is denied, and so they're going to sit in custody and rot away, continuing on indefinitely. And so the judge says, well, there's no way we can let you out because there's nothing that we can possibly do to protect the community. Now, if you're not familiar with criminal law, you might say, well, he was an insurrectionist. He was out there and we don't want him roaming the countryside with his credit card, buying bear spray and then giving it to somebody so that they might use it. Maybe. That's too much of a risk. We don't want to live in that society. Do you want to live in that society, folks? I sure don't. So the government said, well, there's nothing we can do. We can't put an ankle monitor on him. We can't define him to home detention. We can't make sure that he checks in with a pretrial services person. We can't have him call a certain number multiple times a day. We can't put GPS tracking, on him or prohibit him from going to certain places. None of that might work. Continuous alcohol monitoring, drug testing, none of that. All of it is insufficient to make this man safe enough to release. He's so dangerous that we can't even release him because he's got a credit card and maybe some bear spray. But, Derek Chauvin, no problem. You're out on your own, right? Any of the cops who shoot and kill somebody, they're on bond immediately. No problem at all. As are many people who do other heinous offenses. Not the Capitol Hill defendants, though. They sit in custody and rot away because the judges, this is their courts. This is their jurisdiction. They're allowed to do that until the Court of Appeal says, no, not so fast. So here we are, finally. The appeal was considered on record from the U.S. Court of Appeals on the memoranda and the facts that have been presented by the parties. It says here, ordered and adjudged that the district courts may order that we just read, this order right here, be reversed and the case remanded for the district court to order the appellate's pretrial release subject to the appropriate conditions, including what should have been granted in the first place, home detention and electronic monitoring. On the record, we conclude that the district court clearly erred in determining that no condition or combination of conditions of release would reasonably assure the safety of community. Okay, so let's just pause on that for a minute. It's a beautiful paragraph. We don't get many that are that beautiful on this show here, but we conclude that they clearly erred, not even close, by saying that no condition or combinations would reasonably assure the safety of the community. He is now going to be released. They're going to put him on home detention, which is appropriate, and electronic monitoring, very appropriate. All right. Why did the court screw up so badly? Well, although the appellant has not shown that the district court applied a presumption of detention in contravention of the Bail Reform Act and precedent, the district court clearly erred in its individualized assessment, right? So not saying that what the court did legally or procedurally was necessarily problematic, right? Nothing that the judge did actually violated the Bail Reform Act. But the judge is just saying that when you applied this down to this individual defendant, this guy in particular, you totally botched it. There was an individual assessment on the appellant's dangerousness, right? How dangerous was Tanios? The record reflects Tanios has no past felony convictions at all, no ties to any extremist organizations, no post-January 6 criminal behavior that would otherwise show him to pose a danger to the community within the meaning of the act. So, send it back. It's got to go back down. We have a case law here that says that this was a case where it remanded pretrial detention orders where the district court did not demonstrate that it could adequately consider whether they present an articulable threat to the community in light of the absence of a record of evidence that they were committing violence or had been involved in planning or coordinating events in future. Okay, so disposition is not going to be published. The clerk is directed to hold issuance of this because there's going to be a timely petition for a rehearing, probably. Yeah, who is this signed off on here by the judge? Mark J. No, that's the clerk of the court. And who signed off on? Oh, it's pure curiam opinion. Okay, so that was the opinion from the Court of Appeals. And that's good news, right? The court came out and said, listen, DC, when you went through your individual analysis here, when you determined and sort of went through the factors and you tried to apply those to Tanios, no felony record at all. Not a danger to the community. He was arrested several weeks after, if not months after January 6th, had no post-January 6th criminality, had nothing that he was doing, being involved with any of these mysterious, militia groups that everybody from Biden's administration keeps running their mouths about. It's somebody who is just an average person, a regular guy who happened to be there, apparently bought some bear spray at some point in time. Somebody else sprayed it. He sat in custody from, I believe it was March to yesterday, unlawfully, clearly erroneously, because the DC courts are prosecuting people politically. It's offensive. We have here the minute entry now. This is from the district court. So this is going to be going back down to their court. They're scheduled for another court date on September 8th, as we can see here. So it looks like it was scheduled for a status conference, so we don't really know what that's going to be about, but that will be coming up. All right, let's take a look at some questions coming in from watchingthewatchers.locals.com. And I saw a couple super chats come in as well. So we'll take that going as well. Oh, look who's here. Who stopped by? We've got Uncivil Law in the house. He's over on YouTube. Uncivil Law and I did a show. I think we did a stream on your channel. It's good to see you, Uncivil Law. We should reconnect at some point in time. Thanks for being here. Thanks for the super chat. I'll have to swing by and return the favor. We had another one over here from watchingthewatchers.locals.com. Let's see where this is. We have... Wait, I got to get queued up because I forgot. We got to skip some of these questions from the last segment. So it's going to take a minute. We're just going to... A lot of the Nomo Cuomo questions. I know. All right, here's George Tanios. We've got Thunder7 starts us off, says, sorry, Rob. Can't get too excited about this one. One prisoner out of 400 wins in court while the other 400 suffer in solitary, not given bail. I think there will be suicides soon as they lose hope of justice. I hope not, Thunder7. That sounds terrible. I understand your perspective on this, okay? I totally get that. But that's what you need. You need one. You just need one. You got to break the dam a little bit. And then, the first domino falls into the next domino. You build this snowball. You start rolling the snowball down the mountain. Now you've got a precedent. Now you've got precedent, right? Especially if there is a rehearing and the full panel comes back out and says, no, okay, this is how this is working, little DC judges. So if this does now become precedent for all of the other cases, then all of the other defendants can take a look at this and say, well, wait a minute, what happened over here to Tanios? The Court of Appeals released him. I am also a defendant who has no prior record, no felony convictions. I also am not part of any of these militia groups. I'm also somebody that didn't have any propensity for violence after January 6th and have no indication that I'm a violent or dangerous person. Judge. So of those 400 people, how many of them do you think fall into that category? I'm guessing a lot of them do, a significant amount of them. And so they would be able to now use that as precedent, get their own attorneys and say, hey, hello, there's pretty good law that just happened over there. What do you think about filing something similar in my case? And actually the DOJ may just make a decision and sort of respond to that, right? If they feel like they are losing this battle and the full panel might come back and issue an order that might apply to more cases, they may just on their own voluntarily go ahead and start changing policies. So it's a first crack in the dam. It is, I agree, it's a little bit underwhelming when you consider it in the context of the immensity of the injustice that's going on, but it's a start. We've got Sergeant Bob says, thank you for standing up for what is right. Well, thank you, Sergeant Bob, for being here and for supporting the show. We appreciate having you. We have Three Girlies says, could other defendants use this as a roadmap for release? Yes. I mean, look at Jacob Chansley and Couey Griffin. Wouldn't both of their attorneys be able to appear their cases on the same nonsense? And if they do appeal this, would it go to the Supreme Court or is there another step before that? Two great questions, Three Girlies. So let me answer this one first. If they do appeal this, meaning the government, which they probably will, then it's going to go back to the full panel. So right now, it's just 3 judges, and I don't know what the D.C. Court of Appeals looks like, but there's a bigger panel of judges, and so judges sort of will rotate around on it. And so you often see where it'll go to a Court of Appeals, it'll come out one ruling one way, and then they'll say, well, all right, we want to appeal it to the full panel, which is the full assembly of judges, and sometimes it will change, right? And so, hold on to your hats here. This is the D.C. Court of Appeals. I don't know the rest of the makeup of the other judges relative to the 3 that ruled on this case, but certainly you could go through it and say, okay, well, which one of these were appointed by Obama, which one of these were appointed by Biden and Trump and Bush, and you can just sort of see how this might play out. As to the second question, Couey Griffin is out of custody, if I remember correctly, so he's not sitting in there rotting away. They actually let him out pretty quickly, I think only about 2 weeks, so he wouldn't have that opportunity. And Jacob Chansley, I think the reason that they're going to be able to keep him in custody is because of some of the mental health stuff, right? He was going through, which is not appropriate, but he was going through the competency evaluations, right, to determine whether or not he was even capable of continuing to participate in his defense and stand trial. And so when there are some of those additional intricacies there, the court will be extra cognizant before releasing him because they'll say maybe he's not mentally there, right? And so you can sort of see where some of the heightened concern over somebody who might be mentally stable is warranted. But conversely, now you're taking a look at Jacob Chansley and you're taking a look at this DOJ, you're taking a look at the FBI, you're taking a look at all of these DC Circuit Court judges, and you're saying, wait a minute, you're saying he's crazy? Why? And we're supposed to trust you for that and just believe that he's getting the fair shake? that you're telling us he is, when we can just look around here with our own eyeballs and see all of these other travesties of justice taking place on a daily? So no, we don't actually trust you on that. You might say he's mentally incompetent, but you know, my understanding is he's got a pretty decent attorney. We actually did review some of his attorney's background here on this channel, and I don't have anything bad to say about that attorney, right? So I think that it is very important to consider these things on a case-by-case, individualized basis. Great questions. I'm taking a lot of time on these, though. We've got, here is another one. No Name says, they've put these January 6 people in political prison, you know, like North Korea or Russia might do. I'm with you, Rob. This makes my blood boil. It does. It really makes my blood boil. All right. We've got I'm Not Gas says bear spray surprisingly is less severe than pepper spray. It's designed to project a longer distance, but not as burning because bears' noses are much more sensitive and it doesn't need to be. So watch the media pearl clutch around bear spray when it's a much less than lethal option. Interesting. I did not know that, but that makes sense to me. We have another one here from, I don't know what that one is, so we'll just gloss over that. We've got Want to Know says, Rob, read this first. Read first. Isn't... so I can read that publicly. Isn't bear spray an insecticide under federal law? I don't know. I don't know that. Most district attorneys file charges wrong. It's using an insecticide is an assault under federal law. So I'm not sure what they were charged with, but I think that there was... the allegations were physical touching, which may be from the actual molecules in whatever it is. So it doesn't matter what it is. It matters that there was a physical act of a molecule leaving something, a projectile that landed on you. That's the assault, not what this was, not what the molecule was. I think is probably how they have it structured. We have Speech Unleashed. Can lawyers use this for their clients? They're ruling yes. I absolutely think that they can. We have Screw the DOJ is in the house, says, if they can't prosecute 500 defendants in 8 months, and in one case the prosecutors use a Photoshop picture of a naked black man on a Capitol portrait, how could I believe this is not a political prosecution? Robert Barnes is correct. The rule of law is a myth. Laws are created, enforced, and interpreted by people, and the rule of law is a myth used for legitimacy purposes. Yeah, there's... We're not going to open that can of worms. Maybe that sounds like an interesting show topic for maybe Barnes and I can get together and talk that. We got Three Girlie says, one of my fellow security officers and I were involved in a bar shooting in 2013. I had sprayed OC due to the crowd control. We had pushed several fight out of the bar. Shortly before, my fellow officer shot a guy that came into the bar with a gun. The police took my OC as evidence. They tested the guy to see if he came into the bar after I sprayed him or if he was in the bar the whole time. Bringing it back to this, you would think they would have tested the police officers' uniforms to detect if there was bear spray. Who's to say somebody didn't steal it off him and spray it? Wouldn't they have to prove he intended the other guy to use the bear spray? Yeah, right. There's all sorts of just physical problems with this, right? There's all sorts of possibilities where it's hard to, like a punch, right? You can see that it's got a starting point and an ending point. You've got physical damage that's left as a result. With bear spray or other projectiles, especially in a riot scenario where everybody's spraying everything, there's madness, there's mayhem. The police themselves are spraying stuff. Okay, so and we saw that when we went through this case the first time around. People spraying multiple different directions all over. People throwing stuff and stuff exploding in the air. So it was madness. So how, as a matter of law, do you connect the allegation that bear spray left one person's projectile, hit somebody else, and tie that back to a particular defendant? I think it's a difficult task for the prosecutors. We have SDNY is corrupt is here, says, what the January 6th rioter did was stupid, doesn't justify the treatment. Personally, I'd give them a small fine. The idea that judges are objective is a joke. Okay, yes, it's corruption everywhere is, I think, a pretty good summation of that. I saw Uncivil Law there with the super chat, and I think that is it on that segment. So I think we're just going to leave it there. Thank you, everybody, for all of the love and support there. Great questions from watchingthewatchers.locals.com. All right. Thanks so much for watching. Before you head out, I want to just remind you that I am a criminal defense lawyer here in Scottsdale, Arizona, where my team and I, we've got a long history of helping good people facing criminal charges to find safety, clarity, and hope in their cases and beyond that in their lives. Our phone number for a free case evaluation is 480-787-0394. You can also find us online at www.rrlawaz.com. We can help with any type of criminal charge in the state of Arizona, things like DUI, drug offenses, misdemeanor offenses, and we can also help with clearing up old case records, like expunging cases or making sure that you can restore your rights so that you can vote again or possess a firearm again or apply for some other federal benefits. We can remove mugshots off the internet. Basically, anytime that you or somebody you know or love is in trouble with the law in the state of Arizona, we have an amazing team of people. We would just love the opportunity to help. And our phone number, of course, 480-787-0394. And if you don't need any legal services, that's a very good thing. But you may be interested in some informational offerings so that you are prepared if you do have to deal with the police. And of course, I want to invite you to head on over to gumroad.com/Robert Gruler. You'll notice here, I've got several different trainings that are available, including the law enforcement interaction training. This is the 1, 2, 3 rule for dealing with the police. It's one rule you need, 2 questions that the police can ask of you, and 3 responses if they ask you a problematic question. So that's available now. You can also get a load at my personal productivity system here called Existence Systems. Fun little course. And then we have here, if you're a lawyer or a legal professional, be sure to check out this program. We are meeting twice every month. Again, all of this over at gumroad.com/Robert Gruler. And if none of that sounds any good to you, well, just go ahead and give us a follow, because I'm working on some other products and some other offerings. And of course, if you have not already done so, I want to invite you one more time to head on over to watchingthewatchers.locals.com. It's where you can support the show, and it's where we can connect. We've got monthly Zoom meetings and a lot of other goodies coming up. So I look forward to seeing you there. Thank you so much for watching, and for all of your love and support. I will see you on the next one.